To the session co-organized by Medicine Sans Frontiers, Doctors Without Borders Access Campaign, and Health Action International, titled Strengthening and Streamlining National Law Responses Beyond COVID-19, Trade and Intellectual Property Rules in the Context of Access to Healthcare Technology. My name is Yuan Qiong Hu. I work as a Senior Legal and Policy Advisor with MSF Access Campaign based in Geneva. I will be the moderator for this session. A few quick housekeeping rules. The session will be live streamed. Interpretation is available in English, French, and Spanish. Please submit questions by using the question and answers function provided by the online streaming platform. The COVID-19 pandemic has revealed unprecedented and historical challenges in using public health safeguards and flexibilities available under the TRIPS agreement and national laws. The pandemic requires that we rapidly remove all barriers to facilitate uninterrupted production and supply of a wide range of medical tools that can save life globally and can be produced and supplied in as many as possible places globally. These challenges bring into attention of the role of international trade rules, particularly those concerning intellectual property and their interaction with national laws and implementations in safeguarding health. At the WTO, a proposal co-sponsored by more than 60 developing countries and supported by many more to adopt a temporary waiver to certain provisions and the TRIPS agreement has been under discussion for nearly 1 year. Several countries and jurisdictions have also made efforts to improve their laws to safeguard health. In this session, we aim to critically assess the existing public health safeguards contained in the TRIPS agreement, sharing national experiences of using those rules in this pandemic, and also discuss the key reforms going forward. So I want to quickly introduce the panelists with us today. We have the honor to invite Professor Carlos Correa, who serves as the Executive Director of South Center, an international intergovernmental organization. And Carlos is the leading expert in intellectual property, access to medicines, development, and innovation. And together with us, we also have Marcela Cristina Fungata Villarana from Global Health Center Graduate Institute, Geneva, who is a legal researcher specialized in intellectual property and access to medicines. We also invited Jaume Vidal, who is the Senior Policy Advisor of Health Action International Europe. And together we have Sergey Golovin, who is the Intellectual Property and Access Lead from International Treatment Preparedness Coalition of Eastern Europe and Central Asia, joining us from Russia. So without further ado, I will invite Professor Carlos Correa to give us an overview of those public health safeguards contained in the TRIPS agreement, what kind of merit and limitations facing us in this pandemic. Thank you, Carlos.
Well, thank you very much, Joan, for the invitation to the South Center to participate at this meeting. So let me just start by indicating that the very nature of intellectual property rights is to grant exclusive rights, which manifest themselves in legal monopolies. So the concept of legal monopoly is not a political one or an economic one. In fact, in the jurisprudence of the United States and also in European jurisdiction, you will find that patents are characterized as monopolies. And then monopoly, as we know, allow the owner to prevent others from using the technology which is protected, as it is the case under patents. And this has been one of the main issues that we need to address in the context of COVID-19 and beyond that, because it's not just for an emergency like this one. The fact that the technology is monopolized means that manufacturing cannot be undertaken by third parties without authorization of the right owner. I will refer, however, to some exceptions to this, but in principle, this situation. any potential manufacturer may be considered to be an infringer and then subject to some litigation. And this is a situation in which many potential manufacturers will avoid to enter into a particular field. And indeed, what we have seen in the context of COVID-19 is that the very reason for the lack of sufficient supply of vaccines was the fact that technology was not shared, the fact that intellectual property became an impediment for dissemination of technology. And it was the shortage of supply, the very reason why so many developing countries, in particular in Africa, are not able to get vaccines right now. So this is the general scenario in which legal monopolies then prevent access to technology, and therefore there has been one important obstacle in preventing the expansion of manufacturing capacity of vaccines in order to address the huge global demand for this product. Then, as you suggested, there are some flexibilities. There are some elements in the TRIPS agreement in particular that would allow to mitigate the legal monopolies. So these have been extensively explored in the literature. There are some decisions at the national level, also in the WTO, that have addressed the issue of these so-called flexibilities. So let me mention just a few of them in the context of the patent system in particular, which plays a significant role in terms of access or not to have access to technology. The first one is patentability requirements. So although the TRIPS agreement does oblige to grant patents, and it does determine which are the criteria for the evaluation of patent applications, there is a lot of room to apply these criteria in a rigorous manner, in particular in order to prevent the grant of what are called evergreening patents. That means patents in the area of pharmaceuticals which do not actually have any inventive step or novelty. This is very common. There is a strategy by the companies to evergreen the patents. This means to apply, to file for patents with a very low degree of inventive step or no inventive step at all, just to extend artificially the monopoly beyond the 20 years that would allow the protection for the active ingredient as such. So this is a very important flexibility. The South Center has worked quite a lot in this area with other organizations, just to indicate that members of WTO should apply the provision in Article 27, Paragraph 1, in a way that ensures that rigorous standards for patentability are applied in order to prevent the misuse of the system, to prevent generic competition, because if patents and then patent rights are exercised, then generic competition cannot take place, and therefore lower prices are not available. So that's an important flexibility. We also have the so-called boiler exception that allows a generic company to start the procedures in order to get approval for a generic product before the expiry of the patent. This is also important in order to ensure that generic products come to the market as soon as possible. And then thirdly, just to mention a few, as I did said, compulsory license and the so-called government use for public purposes. This is a very important flexibility, which indicates that a legal monopoly conferred by a patent is not absolute. There are situations in which the government may authorize a third party to use a particular protected technology, and even the government can decide by itself to use a technology which is patented even without the request of a third party, a company or an NGO or other institution. This is very important because this means that compulsory license or government use may introduce some competition. So you may have a parallel production and commercialization of a product at a lower price. And therefore, this is essential in order to address medical issues, to address the need to get access to affordable products. And of course, this can also be applied in other areas. However, the grant of compulsory license requires some procedures which may take time. And in some cases, for instance, if a decision is made, the patent owner may appeal and then further delay the execution of a compulsory license. The compulsory license, in addition, is territorial in nature, so as the patents are. So this means that the compulsory license can only be implemented in the particular country where it has been granted. The same, of course, applies to government use. Compulsory license do not apply to patent applications. And in the case of COVID-19, we know there are a number of patent applications which are kept secret for 18 months until they are published by the patent offices. And therefore, this is one of the reasons why the waiver proposal has been made. Although compulsory license is a very important flexibility, is very important in order to mitigate the legal monopoly granted by a patent. In the situation of emergency like this, you need to coordinate action, you need to act fast, and therefore there was a need to make a different proposal, and this is the proposal of the waiver that have been submitted initially by South Africa and India, as you mentioned, has got very significant support from members of WTO. So the waiver will provide a fast solution if approved, and we hope that members in WTO will move forward in order to approve the waiver. The waiver will create an environment of legal certainty. There will be no risk of litigation. It will allow not only the use of patents, but also other areas of intellectual property, because it should not be limited to just patents. It should not be limited either just to vaccines, because there may be treatments which may provide in the end the solution or part of the solution to the COVID-19. So the waiver will allow to address these problems. And as we know, there is an alternative proposal by the European Union that aims at clarifying some issues in Article 31 bis, which was introduced as a result of the Doha Declaration on the TRIPS agreement and public health. But Article 31 bis, and this is actually implicit in the submission by the European Union, Article 31 bis is so complex, so burdensome, that it has not been used as such. Well, there was one case of the previous waiver that was later introduced, Article 31 bis. But the European Union proposal is an implicit recognition of the fact that this is not a workable solution. So my conclusion is that although there are some flexibilities in the TRIPS agreements I've mentioned that have been incorporated in many countries, or not, maybe perhaps although not sufficiently in some cases, there is a need now to adopt a fast solution and a fast approach. An emergency requires exceptional measures. This is what has been proposed on the basis of the waiver. A waiver, just to add a few words, a waiver is a measure which is was already provided, and the GATT is provided under WTO. So it is an exceptional measure, but it's a part of the system. So it's not something extraordinary. And in fact, the previous waiver that led to Article 31 bis is one example of members taking action in order to address the situation of access to medicines. The waiver will be limited, will be on term limited. Also, there will be some limitation in terms of time, and therefore it will not have any impact on further innovation that is argued by the proponents of this alternative view by the European Union and other developed countries. So we hope that members will continue to discuss on this, continue to negotiate in a constructive manner, and in the end, the solution that is sought by the large majority of members of the WTO will be approved. So thank you very much again for your invitation.
Thank you very much, Professor Correa. So now we want to move on a little bit to the national context. In this pandemic, there have been some discussions on reforming intellectual property laws and policies in the EU and member states as well. As we know, EU is doing a counter proposal in WTO, but actually within EU and the member states, some law reform discussion are going on. So I would like to invite German, who is following this reform very closely. German, could you tell us a bit more? What are the key reforms on intellectual property laws need to happen at EU level and within the member states, particularly to mainstream the compulsory license and other health-oriented safeguards? Thank you, German. The floor is yours. I will share the screen of to see.
Thank you, Yuan. And I think that Director Correa already highlighted like the main issues that we're going to be dealing with in this talk. I would like to focus my 5 to 7 minutes, like my attention on the European context, like more specifically, like the European Union context. I think that there is something that we need to bear in mind when we talk about the European Union and the protection of intellectual property. Next, please, is that we are dealing with TRIPS plus framework, in the sense that like requirements go beyond the TRIPS agreement, and especially it's interesting that we have like the patent term are like longer, and then we have like notions like data exclusivity for some sort of medicine, especially for rare diseases, which makes it like more difficult to use some of the flexibilities that Director Correa was mentioning, especially like the border clause. And I think that it's important to see how these TRIPS plus like settings affect governments. And it affects governments at the domestic level in the sense that it constrains their policy spaces, in the sense that there are some like measures that they cannot take, in the sense like, for example, and very specifically on the use of flexibilities, and also limits like the range of interventions. But it has also an external consequence, and this consequence is expressed especially through like the trade deals that the European Union through the European Commission negotiates with partners, where we can see that there is like a projection of these TRIPS plus notions into the legislations of these partners. There's like they're bound by these TRIPS plus when they sign these treaties. And it's important to note that the Mercosur trade deal that was signed late last year, it's like a notable exception on this, in the sense that there is no TRIPS plus clauses. So that was really a good point for like health activists and more or less like all of us who promote an interpretation of intellectual property that benefits access to health technology. It's important to say that while we are really in a TRIPS plus context, there are increasing efforts by governments to make use of flexibilities. And here I have made like a summary, if you're interested in looking at how many times and on what instances have been used flexibilities in the European Union. I would recommend to visit the page of the Medicines Law and Policy, that they have an updated database on the use of flexibilities, and also the webpage of Health Action International, where we have a heat map. And I have like made a difference between pre-COVID and post-COVID, and also very important, like there's a difference between like attempted use of flexibilities and successful, in the sense that there is like many times it has been attempted and not that many times it has been successful, the use of these flexibilities and other health safeguards. And I think that there are like 3 causes that has like pushed like governments to make use of flexibilities. And I think it was at the, like you can see, like for example, Italy in 2005 or 2007, it was lack of competition. But you see like the attempts in Romania, it was because of high prices. And we see like Germany, most especially after post-COVID, is precisely one of the factors that Director Correa was mentioning, like the need for governments to allow themselves like greater policy space. And I think it's important to see how like countries like Germany have made use of it's not only like flexibility, it's more like about leverage, in the sense that they have understood that IP protection as a part of their policy options range can be used to achieve certain agenda goals. Next, please. And I think, as Juan was mentioning, it's important to see also that the European Union, okay, it's this plus, but also it's not static in the sense there are things moving. They're always in a sort of in transit in the sense, and I would like to highlight two initiatives that are currently in discussion between the transit between the European Commission and the European Parliament with input from civil society. One would be the review of the incentive system as part of the revision of the European pharmaceutical legislation and the drafting of the European pharmaceutical strategy. This it's a key element, especially because, as we said earlier on, the issue of data exclusivity, that de facto means a supplementary protection for certain products, makes it really hard, almost impossible, to make use of some flexibilities, not only compulsory license, but also, for example, the Bolar clause or disposition that makes it possible for generic manufacturers to bring the product to the market as soon as the patent expires. And then separately, and that's something very important, we have the IP action plan. And while this idea, one of the goals, it's to promote the fair use of intellectual property, there's something that it's really very telling of the European Commission perspective on IP. It's always part of the industrial policy. It's part of the trade agenda. There's never or almost never this consideration of the impact of intellectual property, for instance, on access to medicines, on access to other health technologies. And this IP action plan that is in discussion, it's a good opportunity to examine one of these elements of TRIPS Plus, that it's the supplementary protection certificates, that it's an extension of patent term protection. And it's there's the risk of there's some quarters that want a unitary SPC that would be for EU-wide. Right now, it's national SPCs. And that's something that it's really, well, I think that many member states are realizing now. They were realizing already 3 years ago with the high prices of medicines, but they are realizing now with COVID-19 related health goods that IP is really has a greater impact that they wanted to concede, at least publicly. And I think it's important to see also these other legislative initiatives at the external level. And I think it's interesting to see the response, right? Because it's not a proposal, it cannot be considered as an alternative proposal from the European Union.
Yeah. Sorry for interrupting. So I think maybe, yeah, so I'm conscious of time. I wonder, yeah, so maybe we pause here after reviewing what happened in EU and by the member states. For the EU proposal, yes, we have to discuss about that a little bit later. Would that be okay? So I would like to move to Brazil and Russia, and then we'll come back to EU.
Thank you.
Thank you. Okay, now I would like to turn to Marcela. In this pandemic, there's also a number of reforms and steps has been taken in Brazil, trying to safeguard public health. Could you give us a little bit of an introduction and overview of the very important reforms that's going on in Brazil?
Thank you, Yuan, and the organizers for inviting me to speak in the panel today. Good morning to everyone, or good afternoon, good night, depending on where you're joining us from. So I'll be happy, of course, to provide an overview of what's happening in Brazil. I just want, before that, to invite people to visit a resource that we have put together at the Global Health Center here at the Graduate Institute of Geneva that compiles also what's happening in terms of IP in a number of different countries, and that resource is available for COVID-19 data resources in the knowledge portal for innovation and access to medicines. knowledge portal ia.org. So there you can find not only what's happening in Brazil, but also a compilation of what's happening in other countries around the world regarding the use of accessibilities and also other changes to IP law in the context of the current COVID-19 pandemic. So for those of you who have been following the discussion in Brazil, Brazil has been trying to undergo a patent law reform for quite several years now, and there are bills regarding to changes in the compulsory law legislation for about I don't know, since 2003, at least. I recall there is the first bill that attempts to change the compulsory license regulations in Brazil. But since then, there has been a number of discussions on how to improve the current law that we have, but none has actually been approved until very recently. I think it was in May. I mean, it's been three or 2 weeks that the new law that proposes changes to the compulsory license provision was actually approved. So it's not totally new law, and it's not as comprehensive as some of the other proposals of reforms that were being discussed. It just implements a few changes to the current law that we have, more specifically in the provision of compulsory license that is for public interest or national emergencies. So Brazil already had a provision in its law that allowed the government to issue compulsory license for national emergency and for public interest. And that's the provision of the law that has currently been changed. So it does introduce new grounds and also a couple of procedures, changes in the procedures to make it more clear, but it's not a totally new provision as there was some bills proposing. And it's not either a waiver, because the first version of this bill, not what was approved, it was actually pretty much very similar to the text of the TRIPS waiver that's currently being discussed at WTO. But that's not what was actually approved. What was approved was just some changes to the procedures of the compulsory license. So I tried to bring here a couple of the main topics that what changed and what was there already before. And what you see in red is what actually was vetoed by the president, because the president has veto power, and the National Congress is going to vote those tomorrow. That's scheduled to happen tomorrow. It might be postponed. So they can decide if they are going to keep these vetoes or if they are going to actually go back to the way that the law was originally approved. So as of now, the provisions in red, they are not in force, but all the other provisions, they are already in force. So I would just like to highlight some of the changes, specifically in the grounds to issue a compulsory license. So as I mentioned before, there was a national emergency, and now they have included a national or international emergency, and also a national state of public calamity. Excuse me. Beyond the public interest that was there before. That changes also because the national state of public calamity can be recognized by the National Congress, not only by the federal executive power. And also, so for that specific provision, the National Congress now has the power to start the process of granting a compulsory license, because that's a two-step process in Brazil. So first you have the declaration of the national emergency or of the state of the public calamity or of a declaration of public interest. And then after this declaration, you actually have the CL being issued. So it's a two-step process. Before, only the federal government could start the process, only the federal government could declare public interest or a national emergency. And now it's the federal government and the National Congress that can start that for these new grounds that were included. There is for the second step of who can actually issue the compulsory license, as of now, it's only the federal government, but there is a provision that was approved by the National Congress, but was vetoed by the president. So that's still to see if that's going to stand or not. That says that the National Congress can also actually issue the compulsory license, but only for public health emergency. So that's something that we are still waiting to see if that's going to hold or not. But we believe that that's a positive step, as you can have another branch of the government also starting the process and deciding on the actual issuance of the compulsory license in case one of them fail to act. So something new that was also adopted was the obligation to issue a list of patents and patents applications within 30 days of the declaration of the international emergency or of the public calamity. So now the federal government has an obligation to issue the list of the patents that can be subject to compulsory license within 30 days. This didn't exist before, so it was on a case-by-case decision. And then for that list, it's mandatory to have a public consultation. So there is obligation to consult public and private organizations for the elaboration of this list. And also, where am I supposed to look? Sorry. Okay. And also there is a possibility for public and private institutions to suggest what patents they think is relevant to be included in the list. So here I also call attention to the fact that this list can include applications. As Professor Carlos Correa mentioned before, there is always it's not very clear if a compulsory license can be issued or not for patent applications. So that has always been a subject of discussion also in Brazil when we are looking to some of the patents that potentially could be subject of compulsory license before, and if they were still pending applications, there was always a discussion if it was possible or not to grant. So this law now makes clear that patent applications can be object of compulsory license as well. And then there is a provision that says that for the payment of royalties, it only starts well, royalties are only due in case the patent actually gets granted, even if the calculation of the royalties goes back to the time of the actual compulsory license. So, so even in the time that they still pending analysis, the patent holder is already can already claim royalties, even if the patent is going to be granted only in the future. So there is also a couple of positions, and then another part of the procedure that's also seen as positive is that between there is now a timeline that has to be followed by the executive government of 30 days, with possibility to be extended by another 30 days after the publication of the list. So in total, it would be like a 90 days procedure maximum to have the decision on whether or not to issue the compulsory license. And before there was no timeline. So this is something seen as an improvement in the process and also brings more clarity to the way that's going to be done. I just want to call also attention to two other provisions that it says in the law that in some cases, the patents cannot be subject to compulsory license, especially if they have been object of technology transfer agreements or if voluntary license. And also in case after, I mean, those, they cannot even be included in the list if there's already a technology transfer agreement or a voluntary license in place. And if they are included to the list, but the patent holder or applicant makes objective commitments to meet the national demands in terms of volume, price, and time, they can also be excluded from the list of patents that can be object of compulsory license. And the last thing is regarding the obligation to share technical information, data, and biological material. That's of now, that's also being vetoed by the president. So we are not sure if that's going to stay in the law or not, but it made mandatory by the patent holder and the applicants to share all the technical information necessary for the reproduction of the patent object. And one thing that is now in the law that wasn't really clear before and has been raised as a limitation in the procedures in Brazil before this change was that it makes mandatory for any public institutions that holds any relevant information for the reproduction of the object to share with the licensees. So we are specifically talking here about data requirements, for instance, that are submitted to obtain sanitary registration by Anvisa, the Brazilian health authority. And before it wasn't clear if Anvisa could or not make this information available to the licensees, and now they have an obligation to make it available.
Okay,
so Brazil.
Thank you so much, Marcela.
Thank you.
Yeah,
that was
so okay, thank you. So as we see a lot of innovation in this law reform, and hopefully the vote tomorrow will support the most important clauses to go through. So now I want to turn to Russia and invite Sergey to give us also an overview, because Russia is among a few countries in this pandemic who actually issued the compulsory license, and then law reform has also going on for quite some time with this very robust civil society engagements, advocacy. So Sergey, the floor is yours.
Thank you very much, Johan, and thank you very much for the opportunity to speak at this really important session and share some thoughts and some information about the recent government use license for remdesivir in Russia. And as Professor Correa has already mentioned, such things take time. And it's important to remember that there was a very, very long process behind this decision, and it basically started for the civil society in the mid-2000s when the Russian government started to pay for ARVs for the HIV meds, and I think the first campaign was organized in 2006 when patients started to become aware of this issue of patents and patent protection. And there was not a lot of understanding about the technical legal issues around compulsory licensing and patents as such, but there was this very, very simple idea behind it, that people basically could see that if the Russian government could buy cheaper drugs, it meant that more people could receive life-saving treatment. And that meant that fewer people, including their friends and relatives, would die. And it was as simple as that, but from this very simple and very powerful idea grew a movement to support those TRIPS flexibilities. And there was another big push in 2015 for ARVs, and there was another big push for HCV, so Sofosbuvir and Decladazvir in 2017. And although the actual decision to issue a government use license was not implemented in those two cases for HIV and HCV, I think still those campaigns did lead to significant improvement in terms of treatment access. And it's important to remember that. Now coming back to remdesivir, on the slide you see a summary of this decision, so I would not go into too much detail on that. What I have to say is I think it's pretty specific. It mentions a specific company. There is a specific timeline. There is, of course, a referral to a specific clause in the law, etc., etc. But at the same time, it's pretty concise. So we have the translation available, so I could share it later on, and then I'm going to talk about the actual remdesivir decision in a bit more detail later on. But can we move to the next slide, please? Yeah. Another important thing to bear in mind is that for a CL campaign to be effective, you need a transparent and easy to understand, detailed legislation, regulatory framework. And we have this specific article, Article 13660 of the Civil Code, stipulating possibilities for the government use. And there was a process started several years ago, and it was strongly backed by civil society, but some of the civil society organizations to actually include healthcare into one of the into the list of grounds for issuing government use licenses. And it basically took a whole pandemic to finally implement this. So in May 2021, it's something Johan was referring to, this law finally came into force. So basically we now have public healthcare as one of the reasons for the government to issue a government use license. Before it was only national security. But importantly, the remdesivir decision, which was taken in 2020 in December, it was taken in accordance with the previous version of the law. So it basically means that governments can act even within those limits without specific mention of the public health care, and it only takes, I think, political will, and it still complies with the TRIPS flexibilities. And there was another law which came into force in 2021, enabling the Russian government to use CL for export. So basically implementing and integrating the 31 bis into the national regulatory framework. And it's very new. And again, there was a whole pandemic. This was a long process, but we see the actual results after a very, very long campaigning process, and after the COVID-19 pandemic started. So those two really important factors, I think it's really important to bear in mind. It has to be consistent, and it does take time. Next slide, please. Some important things to mention about the remdesivir license. So we did start speaking to the government while communicating with the stakeholders around the possibilities to use CL when the clinical data was emerging about remdesivir. So unluckily, we have now this conclusion by the WHO saying that its clinical benefits are not clear. So basically, WHO does not see the clinical benefits of the remdesivir. But I think still it was important that the government acted because, again, it's a pandemic. And as we saw in the case of Israel, Israel acted pretty quick and it issued a compulsory license for an experimental drug. It was lopinavir-ritonavir. And later on, it turned out that lopinavir-ritonavir was not effective against COVID. But still, it was important that at this point, those TRIPS flexibilities were implemented because it's essential to act quick. So we see that there were some counter measures taken by the patent holders. There was a lawsuit. I think many of you are aware of that. So Gilead sued the Russian government for this decision. It went to the Supreme Court, and they lost. But so as mentioned by some of the panelists, there can be countermeasures which can impede the whole process. And it's important to bust some of the myths around CL again. And this is what we see now with the remdesivir license, that the patent holder is on the market selling remdesivir. It's what we see based on the analysis. And although the sales volumes of the patent holder are very, very small still, nothing prevents them from actually entering the market and selling, even though there is an effective government use license in place. So next slide, please. I think it's the last slide. Yeah, about the further considerations. I would like to reiterate that, again, for a successful government use campaign, that's what our experience shows. It's crucial to have a very favorable regulatory framework. It acts like a strong leverage for those campaigns. And with regard to the countries of the Eurasian Economic Union, such as Kazakhstan and Belarus, we saw, for instance, that a lack of effective tools in the regulatory framework was an obstacle for effective use of compulsory license, for example, in the case of dolutegravir. And I think there has to be a really strong there is a strong push already from the civil society, and we really need backing from the governments to bring the legislation in line with the TREPS flexibilities to allow more effective use of compulsory licensing mechanism. It's absolutely crucial because time matters, as Professor Kara said, and it's a very, very important part. And it would be great if there could be more collaboration with Brazil, with the Brazilian reform going on, and the hopefully reforms in Kazakhstan and Belarus, that we all bring together and actually speak to each other about the importance of those measures. And safeguarding other TRIPS flexibilities like the patent linkage regime, which is under discussion in the Eurasian Economic Union countries. And we are trying to do our best that this does not get implemented in a bad way, so it does not affect the BOLA exemption, which was already mentioned. So it used to be an effective mechanism for enabling faster access to generics, and I think it's absolutely crucial that we don't lose it with the new rules under the Eurasian Economic Union. And I think honestly, we should not be discussing measures strengthening IP protection in the middle of the pandemic, and that's our message, I think, for the stakeholders in this process. And I think at this session, it has to be an important conclusion that the only measures we should be talking about in the pandemic is how to loosen the IP protection, how to better use TRIPS flexibilities, rather than discussing how to make them harder in case of like this patent exemption. And of course, totally, we should be supporting the TRIPS waiver in response to COVID. With that, I would like to finish, and thank you again for the opportunity to speak. Thanks.
Thank you so much, Sergey. I think that is really, really rich exchange between the different national experiences. I think we have heard both in Brazil and Russia, civil society have gone through very long time battle. It is not something happening overnight. So in COVID, so we have to be, people have been preparing the law to be enabling to support health for very long years. So even within the COVID, there is some success, there's some challenges. So we still face the, in order to save the legal innovation in Brazil, they have to survive another vote tomorrow because of the partial veto by the president on some of the most important clauses in terms of sharing, mandatory sharing of technology. And then in Russia, we had faced the retaliation from companies. Even government was making the illegitimate use. So all of this also come back to Carlos' earlier remark. There's a sustainable law reform that are needed that probably take time. But in the pandemic, we also need immediate solution, like short-term solution to enable country to act quickly. So if we can come back with a bit elaboration, if I can come back to Carlos. So in terms of the TRIPS waiver, I mean, after the legal analysis, it's quite obvious for us, right? So this is kind of short-term solution we could help country. Unfortunately, EU, UK, Switzerland, and Norway, in a sense, still block this whole discussion. Could you kind of comment a little bit this scenario when legally speaking it's obvious, but then politically speaking, there's still country blocking others?
Well, thank you, Joan, for the question. Yes, well, it's difficult to understand the rationale for this position by these countries, because on the one hand, they are arguing that this may have negative implications on further innovation on this. But clearly the waiver will be limited, as was mentioned before. And there is overwhelming evidence that the companies, the Western companies that develop vaccines, which are now being commercialized, receive massive subsidies from governments and other institutions. So they did not invest their own money, but the public money. So the rationale for the intellectual property is a market failure when the investor or the inventor cannot recoup the investment they have made for research and development. But this is clearly not the case for COVID-19 vaccines. the investment was paid by somebody else, by governments or other charities. So it's difficult to understand the argument. In addition, there is also this consideration that the technology may be used in other fields, but the waiver is limited to COVID-19. So this is not real problem. Of course, there may be learning of the technology, but this will happen in any case. So I would say that this opposition does not take into consideration that it will take longer to develop alternative vaccines, to expand production, but this will take place. For instance, now there are at least two advanced developments of mRNA, the messenger RNA vaccines in China and in Thailand. And it has been done without the cooperation of Moderna or Pfizer that have commercialized the vaccines. So this will happen. The problem is they will take longer, and we needed a very fast response to this crisis. So I hope that they will change the view. The proposal of the European Union, as I mentioned before, is not a real alternative to the waiver. It's just introducing some clarifications which in the end are not actually needed. MSF has produced an interesting analysis on this. So it just proves that the system under Article 31bis is not operational, that there is a need to reform. And this may be perhaps one of the conclusions of our discussion, that there is a need to go back and look at the current system and what reforms are needed in order to address situations like this and beyond an emergency situation, access to medicines and vaccines and other pharmaceutical products in general.
Thank you so much, Professor. So if we follow, this is really to the kind of a spot on observation. If we follow a little bit on the EU, as the German mentioned a bit, if we come back to that, there's a lot of reform discussion in EU and the member states, but EU, it has taken a very different approach. So German, if we come back to a little bit the EU's blockage at WTO and their approach, could you give us a little bit of comment on this approach?
Yeah, thank you. I think that you are really right, spot on when you use the word blockage, in the sense the European Commission is really, we have to say that it's not engaged in good faith in negotiations. Like for a year, they have been asking for further information and clarification, which has been provided by India, South Africa, and the rest of 60 co-sponsors. And then just like 3 months ago, they come with this document that they want to present as a counter proposal or alternative. And I think it's very interesting what Director Correa was mentioning, in the sense that this document, it's built around like a reinforcement of Article 31bis, which was already a product of a compromise on the paragraph 6 of the Doha Declaration, in the sense that we are discussing at 2021, we're discussing issues that are still pending from the Doha Declaration, in the sense the Doha Declaration that was, even for some of us, was heralded like a victory for like health activists and global South countries. Well, it has never been fully implemented because there were some issues, like for example, how countries with no pharmaceutical manufacturing capabilities can make use of these flexibilities like compulsory license, that now are revealed to be essential, in the sense the fact that there is no capability to manufacture vaccines in the whole African continent 25 years later of the TRIPS agreement that was supposed to be like transfer of technology in exchange for enforcement of IP, I think it's scandalous. Also, I think it's important to see that the European Commission, let's be clear, in the sense there's the European Union and there is the European member states and the European public opinion. And I'm not sure at all that the European Commission is representing the European public opinion on this issue. There's a resolution by the European Parliament calling and demanding the European Commission to engage and really negotiate, not filibustering, not opposing, but engage in text-based negotiations, that it's not being followed by the European Commission. And you can see like surveys in several European Union member states like Spain, the Netherlands, even France and Italy, like citizens support that there's like a scaling up of production. So I don't know really what's going to happen, but I think that we're going to be seeing changes in the coming weeks, especially as we get closer to the ministerial conference. I think the European Commission has to realize that the pressure is on them to be part of the solution and stop being part of the problem.
Thank you so much, Jeremy. It is a very powerful message to the European Commission and the member states. Hopefully they will change and deliver. So if we come back a bit to Brazil, Marcela, so you introduced very important legal innovation actually in this battle of reform, but it's not a very smooth process already. But then some of the key clauses such as, including the patent application under the compost license and linking the licensing with mandatory sharing obligation, or enable at least the regulatory body as Anvisa to share information, facilitate production. Those are super important reforms. And then we hope, again, the vote tomorrow will go smoothly. So if you could share with us a bit, how do you see this national kind of reform process, put forward by civil society and with success, would kind of correlate with Brazil's possible kind of a more positive role in the international forum, including in the WTO, when Brazil actually has a lot of experience in using the law to safeguard health?
Thank you for the question. I see that we have 6 minutes, so I'll try to be brief. I think the main conclusion that we can have, Brazil used to be leading the discussion about public health and trade and the use of flexibilities in international forum. At the same time, applying some national policies that was not exactly in line with the public health interests. So we always used to say that there was a mismatch between the international discourse and the national discourse. And I think what we see now is a change in that. What's happening at the national level is actually being much more pro-public health than actually what the Brazilian government is supporting now in international forums. As we know, Brazil is not one of the main supporters of the WTO TRIPS waiver as of today. It stopped blocking it, and now it's supporting, but it's not as active in these discussions as it was historically in discussions regarding public health and TRIPS. So I think there is lots to that. What's happening in Brazil, it's the approval of the compulsory license bill, even if it's not what we the one that could be most relevant for public health in the terms of actually automatic granting of license, or the bill that was more of the TRIPS waiver. That's not what was approved, but what was approved was already an improvement to what was the law before, and also the decision of the Supreme Court, recent decision that about the extension of patents beyond the 20 years, that was also revoked from the law. I think those are important lessons that can also build a support for the government to be more active in the way that it is acting in the international forums now, and try to be more supportive of the waiver. Thank you.
Thank you so much, Marcela. That's very helpful. The role of judiciary absolutely is very crucial in the national context. So yeah, we are running out of time, but I want to give floor back to Sergey. As you already mentioned, there's a couple of TRIPS plus issues that we have to watch out. So if you would like to revisit a bit more, in Russia and in the region going forward, what would be the key reforms you think should be considered?
Thanks very much, Jan. Well, the key reforms, like very, to put it very short, it would be a favorable regulatory framework for government use licensing, and of course opposing the patent linkage regime, which is now being introduced, or there is a lobby trying to introduce this strong patent linkage regime. And I think this is not something we have to talk about in the middle of the pandemic. That it has to be vice versa. It has to be like more favorable laws. And again, I would have to stress that for many countries of our region, like specifically for Kazakhstan and Belarus, they have to implement transparent, easy to use government license mechanisms. And my final, I think, remark, which is I think very, very important, it's crucial for expert organizations like ours and beyond to talk more about the TRIPS flexibilities for the general public, to build this momentum. I was actually fascinated to see this happening on Russian TV on like Channel 1 and Channel 2 when the people discussing the government use license. It was like really something not something we're used to. So I think we and other organizations have to do even more beyond what we're doing to actually convince the general public that it's something good, it's something favorable, it's something important for their lives. That's my final remarks.
Thank you so much, Sagi. So the last 2 minutes, I want to get back to Carlos, because you have been instrumental in driving this international movement. You witnessed the Doha Declaration, and you witnessed now this pandemic. If we see, if we want to invite you to have one sentence to the government who are coming to Geneva in November, sitting in the ministerial conference, deciding the very important waiver discussion and going forward, what will you say to those governments as a concluding remark?
Well, thank you for this opportunity again, Joan. Well, I will tell the governments that they need to act. So this decision has been delayed for so long. There is a need to act. There is a need to recognize that this is an exceptional situation which requires exceptional measures. If this is not done, the government still have the possibility of using the TRIPS agreement Article 73B, the exception for national security, but this will be done under its jurisdiction. So it would be much better to have a global solution to this. So the choice is between a global approach, which will be provided by the waiver, or a solution will be based on individual decision by government. So if the waiver is not approved, government should actually use Article 73, Paragraph B, and then suspend patent rights and other rights and expand the manufacturing capacity. And also, I would like to argue that in terms of innovation, it'd be important to look at compulsory license for know-how. It is often said that the very obstacle now to expand production are not patents but know-how. So there is a possibility, this is not prevented under the TRIPS agreement, to provide for the non-voluntary transfer of know-how. The South Center has recently published a paper on this. So I think that's another message. There is a need to innovate within the context of TRIPS agreement in order to pursue the objective of providing vaccines and other products needed to address this emergency.
Thank you so much. Okay, so we are concluding the session, and then thank you very much for everybody, and then we will see you in the future.